Hello, everyone. My name is Rebecca, and I'm an event planner with the Orange County Library System. Welcome to tonight's virtual event, Ask a Lawyer, presented by the Orange County Bar Association. In tonight's event, you will have the opportunity to speak with a panel of attorneys to get insight and guidance on consumer law and small claims. Before we begin, I would like to share a couple things about Zoom. Please keep in mind that everyone's videos besides our speakers will be turned off. You will be muted unless you are asking a question, then you may unmute yourself. If you have a question and would like to speak, please use the raise the hand feature at the bottom of your screen, located under the reactions button. Also at the bottom of your screen, you'll see a chat feature. So if you would like, you can go ahead and let us know in the chat if you would like to, if you have a question, we'll be using that as well. I'm going to be putting a numbered list in the chat to show who will be next. So please respect others and wait to be called on. We want to avoid people speaking out unless it's your turn. If you do speak out of turn, we are going to mute you just until it's your turn. For those of you who are calling in, if you want to speak, just press the unmute button on your phone. I'll see it and then we'll add you to the numbered list as well. So just wait to be called on and then you can speak. Without further ado, I'd like to begin by introducing Marianne Etzler. Thank you so much for being here. Marianne is our moderator for tonight's event. I'm going to go ahead and turn it over to you.
All right, thank you, Rebecca. Good evening, everyone. Again, my name is Marianne Etzler. I am the owner of Etzler Law PA, and I'm a member of the Orange County Bar Association. So I'd like to thank everyone for attending our Ask a Lawyer event tonight, sponsored by the Orange County Bar Association and the Orange County Clerk of Court's office. Before we get started, allow me to give you a little background about the Orange County Bar. The association has been around for 85 years. In addition to serving the needs of our members, one of our goals is to reach out to the community and provide services and programs that will benefit Central Floridians. Some of our programs include our members' pro bono work with the Legal Aid Society of the Orange County Bar Association, our lawyer referral and information service, our Law Week program, and our free Citizens Dispute and Family Law Mediation program, which, by the way, is a really great program and it's free. The Citizens Dispute and Family Law Mediation is facilitated by an impartial professional mediator who listens to both parties and encourages the resolution that is satisfactory to both parties. And it is a free program for anyone residing in Orange County. So tonight's Ask a Lawyer event is just one of those programs for us reaching out to the community. We hope you will feel free to ask any question that you have about consumer law and small claims. The Orange County Bar attorney, Louis Basagoitia, and myself will help guide you through some of the issues that you may want to know or you may have questions about. Tonight's event will be recorded and shared with the Orange County Bar Association's Facebook page. So be sure to like the page if you are on Facebook. So at this point, I'd like to introduce the Orange County Clerk's Office, Stephanie Woods, the Operations Support Coordinator for the Self-Help Center at the Orange County Clerk's Office. Hi, Stephanie.
Hi, thank you. Thank you for having me. Good evening, everyone. Again, my name is Stephanie Woods, and I do work at the Orange County Clerk of Court's Office in the Self-Help Center. And I do have a brief PowerPoint that I want to give you some information on what we do. Just going to share my screen. So our Self-Help Center was opened in 2015. It's a legal assistance for underserved customers who don't have legal representation. So pretty much you are considered a pro se litigant. There are attorney consultations are virtual. Prior to COVID, it was we had someone did come in, but now it's all virtual. So when you go onto our website, please read the disclaimer that it is virtual. So we do not want you coming all the way down and there's nobody here personally to speak to you. We are located on the Orange County Courthouse on the 3rd floor, room 340, and our center is open from 7:30 to 4. Our case types are evictions, family law, small claims, and also unlawful detainers as well. The services provided again is the virtual attorney consultations. We do sell forms for small claims, unlawful detainer, evictions, and family cases. We do provide notary and copy services. We do have landlord guidance, tenant guidance brochures for you to receive, which is located in our office. And the computers are available for court-related business. If you need to print something that you need to put in your court file, you're more than welcome to stop by. For our virtual attorney consultation, our appointments can be made online with a credit card and includes a $1.50 convenience fee. In-person appointments can be made in our office in room 340 and must be paid in cash only. Again, if you're coming in person, we can schedule for cash only. Otherwise, you do need to go online and you would have to pay online with your credit card. The attorney appointments are $1 per minute, 15 minutes minimum increments, up to 60 minutes per day. So it's $1 per minute, 15 minutes minimum, 60 minutes max. Customers will receive an invitation via email and to attend the virtual appointment with the attorney. Please, if you do schedule your appointment, make sure that you check your clutter and your spam. It'll be a no reply email from the Self-Help Center, or you'll get something. If it's not a no reply, it will be actually from one of my clerks. It'll have the @myorangeclerk.com behind their name. So you're able to get all the information that you need when it's time to have your appointment. So here is our website. It's at the myorangeclerk.com Self-Help Center and the Contact Self-Help Center. So there's actually nodes that you can go through. And their number is 407-836-6300. And here is our address at 425 North Orange Avenue, 3rd floor, room 340 again. And again, our hours are Monday through Friday, 7:30 to 4 p.m. And again, this is our information here. I'm sure if we can leave it up a little bit if anybody needs to jot this down so that way they can have it for their records. And Marianne, is there any way we can share this in the chat just in case somebody comes later? Or
This is something that I'll share in a follow-up email to all the attendees.
okay. All right, well, I'll go ahead and stop sharing. And thank you again. My name is Stephanie Woods. And again, I am the Operations Support Coordinator in room 340. So if you come up, we're there to assist and help you to get the brochures you need so you can start your case. And again, virtual attorney consultations are online virtual. Again, it's $1 per minute, 15 minutes minimum, 60 minutes max. Thank you.
Thank you, Stephanie. It is a really great program. So many people have been helped by that program. For a time, I was one of those attorneys that helped people, and it's just a really good program. All right, so we're going to go ahead and open the floor to questions. Any questions that you may have regarding consumer law and small claims matters. Do we have anybody in the chat? We are ready to, let me see. I see one question. Why is the term virtual used when referencing an attorney? Do you realize virtual means not real, as in the attorney would be an AI app? Okay. Well, I don't know who uses the virtual term. I don't know why they use it, but I can't answer that question. So
yeah, it's just a terminology that the clerk's office use, but it is a face-to-face with an actual attorney. So it's no machine or anything answering your questions, but it is an actual attorney that is answering your questions when you come on and you log in.
Right. So if you have a question, feel free to use the raise your hand feature to ask a question, or you can add your question in the chat. All right, so Chantel, you are first. If you want to go ahead and unmute yourself.
Okay. Can you hear me?
yes.
Okay. I have a question. I was going to purchase a puppy, and we had made agreement via text. And she wanted a $250 deposit to hold the puppy. And so I took her the money, and it come up where my mother was sick, really sick, so I had to go stay with her. The puppy wasn't ready to come home for at least another, I believe it was 6 weeks. So I contacted her and let her know at this point, I really wasn't going to be able to get the puppy this time because I had to care for my mother out of state, and asked if I could have a refund. And I actually gave her $50 more than what she had requested for a deposit. And she had put in the text message that it was non-refundable if I decided if I couldn't get the dog. So that was in the text message, but I was just wondering, I'd like to have the refund because I didn't get any money back, nor did I get the puppy. Is the text message legit enough as a contract to be able to not get a refund on that, or would I be able to take her to small claims for that?
Louis, do you want to take that or do you want me to?
Yeah, did you agree? Did you text back that you agreed that it was not refundable?
I didn't really agree. She just stated something and I said, okay.
Well, okay is an agreement. I would say that it is binding because she could print that out, and I think that would be a contract, and I don't think you can get your refund back. Marianne may have a different look on this, but that's what I
No.
think.
What we're looking at is, does it constitute an offer and an acceptance? If she offered the puppy to you for a certain price and you accepted that by agreeing to it in a text, then she could use that to try to hold you to a contract. If you hadn't already paid her, she could potentially hold you to that. So if she wants to refund the money, that would be up to her, but I don't see any legal recourse for you to get a refund because you did agree to it.
Okay, that's all I need to know.
Okay.
All right, thank you.
You're welcome.
All right, so next we have Lawrence. Lawrence, was your question about
I just wanted to know, I had been asked about I guess it was Tyler Technologies that contracted with the Ninth Circuit for a sort of online dispute resolution option of small claims. And I had a anecdote of somebody trying to use it, but the other party never responded to the automated request for offers. And it just kind of kicked them back to regular court, and they had to have a hearing and everything. So I was just wondering if it's been successful in eliminating the number of cases and small claims, or it's still, is it a pilot program, or have we gone permanent?
honestly, Lawrence, I don't know. I thought it was still in the pilot program stage, but I haven't been to one of our judicial relations meetings recently, so I don't know if it still is or not.
Yeah, I just was sort of asking it from the clerk's office if you knew anything.
And I don't know, Candace might know. Stephanie, do you know the answer to that?
Hi, sorry, no, Marianne, I
Madam
don't
Chair.
have that information either.
Okay, do you know who would have stats for those cases in the clerk's office?
That would probably be court administration. There's a number if you just want to call the 836-2000 and speak with administration. And maybe I'm sure they'll probably be able to assist you, but I wouldn't be able to answer that. I'm sorry.
No worries.
Thanks, Lawrence. All right, so the next person I have is Jasmine.
Hello, hi, Jasmine here. Okay,
Jasmine.
so I'm gonna make this quick. I don't want to take too much of your time. So I hired a lawyer to get a divorce, and I paid her a retainer. And then the way I wanted to file my divorce was without an MSA. And she said, oh, that's against the law, Florida law. You cannot do that. So I actually went to the e-file thing, self-help And I was able to file myself without an MSA. The court approved it. The case is closed. I guess that my divorce, that just happened last week. It says case closed when I look up the case. So it looks like everything was finalized with the divorce. And since my lawyer did nothing for me, nothing, am I able to get my retainer back?
Marianne, you go ahead if you know.
So I guess that would depend on what the attorney had done. I don't know whether the attorney had done any paperwork before you went and did it on your own.
Nothing.
I don't know what your contract and your retainer agreement says with the attorney. So
Nothing. And I have an email from her where I asked her, I said, so she has verbally offered to give me back my retainer. And I said, hold on to it because I might, still need your help. So then she comes back to me and says, well, for being available, she kept my retainer. And I said, so from when has being available billable? And I have all that in writing, in email.
okay, so it really does depend on what your representation agreement says. So when you sign that representation agreement with her, in some of them, they actually do have a non-refundable language where you pay that retainer and it is non-refundable. So I don't know what your retainer agreement says. I don't know all of the specifics of what transpired between the two of you. And so I don't think that I can really answer whether or not it should be refundable or not. But I will tell you that there is a mediation program through the Florida Bar for these kinds of cases when there's a dispute with an attorney that can be handled if you don't go through the Orange County Bar and handle it through their citizens dispute, which is that you could also do it that way. But sometimes when people make complaints about lawyers, especially things like this, they do have a program where they can try to resolve it without it becoming a really blown up thing. It costs you a lot of time and effort and potentially money. So it depends on what your retainer agreement says, the representation agreement. That's where you'd have to start. Look at the language and make sure if you've read through the entire thing and whether or not it's a non-refundable retainer, because many attorneys that are family law attorneys will actually do that as a non-refundable retainer.
Well, the fact that she offered verbally to refund it twice, and I said no. I said, hold on to it. But when I did ask, she said I was always available. But okay, so how would I go this program? How would I go about
So you can contact the Orange County Bar and ask them to do a citizens dispute mediation with them. It's free. And you could also contact the Florida Bar. You can contact the section that handles lawyer complaints, and they could give you the information on how to set up a mediation to try to resolve the dispute that way.
Okay. And so I would just find all of this on the website?
Yes,
Or
ma'am.
okay, thank you.
Okay. Let me see. Next, I think was John. It looks like John requested information about finding an attorney for an assault case. We're not talking about those kinds of cases tonight, John, but if you do need a referral, you can certainly contact the Orange County Bar. They do have a lawyer referral service, and that would be a starting place for you, is the Orange County Bar Lawyer Referral Service. And I think, Rebecca, you can provide that phone number as part of the information that you send out to them after we're done tonight. Is that right?
Yes, absolutely. I will be sharing that information in the follow-up email.
Okay. All right. Next person I see is Carmelita.
Yes, ma'am. Carolina. Yes, ma'am.
Okay. All right.
How you doing?
Do you have a small claim case?
No, this is, look, this is my situation. Okay, this is what I was. I did a small claim myself and I was representing myself. Actually, I do have a company and that was me, and I did a small claim to Amazon. And this is what I was. We went to mediation. I was, we did a virtual. So what it was is we negotiate in the small claim. It was for a lost merchandise. They lost my merchandise. I sent it to the FBA fulfillment by Amazon and they lost it. So I went myself without an attorney and I went to Orange County. I pay and I did this claim. So, okay. So this is what it was. So we went to mediation and we negotiated mediation and we said that they're gonna give me $500 plus the remaining of the merchandise item that it was in the warehouse. So what it was is in mediation, I don't know what happened, but they never did the court documents. It was no court documents because when we finished mediation, the mediator actually, they were like almost going to do the document, but Amazon, the attorney told them, you know what, we had to do it. So the mediator told Amazon, okay, that's fine, you do it. And Amazon did the documents, but the documents that they did it was a dismissed case. And they sent me a dismissed case, and actually I signed, okay, because I was thinking, you know what, we went to mediation. I was thinking, you know what, this is very serious. We were thinking, you know, we actually spoke what we're going to do, the 500 plus the, you know, the remaining of the merchandise. In the end, the only filing document was a dismissed document. So we went mediation and it was no document filing by the court, by the mediator. The only thing was filing, it was a dismissed case. So me, I got a little bit upset about the situation because I was, oh my God, I cannot believe it. I went to the court, I paid the fees, we went mediation, and it's no documents. The only documents that is filing is a dismissed case. So I start sending messages to Amazon attorney, but after a month and a half, in the end, they sent me a check yesterday, okay, for the remaining items that it was lost in the warehouse. And you know, I'm not coming back, but you know what, to be honest, I got a little bit of, I didn't like it because I feel bad because I say, you know what, why they did this to me? Because I don't have an attorney. So because I don't have an attorney, I went to mediation and it's no documents from the court other than filing dismissed case from Amazon. When we negotiate mediation, what we're going to do and what this is gonna happen after mediation. So I don't know, this is really my question. This is normal, or this is something that is not normal?
Okay, so what is it that you want? Do you want the $500 back?
No, they already pay me, you know, they already pay me the 500 and they already sent me the last check yesterday for my case, okay? But my really question is, why we went to mediation and the court, they never did the court order? Why in mediation, they decide that Amazon is gonna do the documents, but Amazon, they never explain nothing in the documents. What Amazon did, it was a dismissed case and send it to me and I signed. Because
but you did get everything that they agreed to in the mediation, right?
No, yes and not. Yes, but yes. The first part, which it was the 500, but after I had to start sending emails to the attorney. And actually I sent the email to the Orange County mediation email from the beginning to letting them know that actually they never pay me for my remaining merchandise. But in the end, what it was is, when I called the court, they told me it is really nothing that we can do because it's a dismissed case filing in court.
But you did get a payment for your remaining item finally,
yesterday.
right?
They just sent it to me yesterday, but I've been for this for 3 months already. Yes.
Yes. I mean, I don't know why, you know, I guess it's up to the mediator, you know, who does the agreement, but I mean, you said that you signed the dismissal, right?
I signed it, but it was my mistake too. You know, it was really my mistake because I didn't have representation. I was very naive, thinking that everything was very serious because we went to mediation and we negotiate. What is going to happen?
Well, if you signed the dismissal, I mean,
I did.
You know, so I think there's nothing, you know, that's your responsibility.
No,
you need to write, you need to read what you signed. It's too late now to do anything.
Yeah.
You got your stuff, you got what you had coming to you. So I mean, as far as your question, whether this is out of the ordinary, I mean, the attorney should have provided with you with the agreement, but on the other hand, you know, you signed the dismissal, so you made a mistake as well.
No,
so you know, you should have asked for the mediation agreement. But yes, you're entitled to the mediation agreement, but again, you signed the
I
dismissal.
signed it. No, and I
so-
understand. No, and I understand it's really nothing that I can do. And in the end, I already got the check. I already got the last check
Right.
yesterday. But, you know, to be honest, from the bottom of my heart, I felt bad. Why? Because I went to the court and I paid the court to do a lawsuit for a small claim. So why, if I don't have an attorney and I am going to mediation, why the court is not protecting me? When I mean protecting, and why they didn't do the documents at that moment, the court documents.
Let me,
There's no obligation to prepare the mediation agreement. Go ahead,
No
Mary.
obligation.
yeah,
Okay.
I think what she's asking is, you know,
Mhm.
why didn't certain things happen a certain way? So, ma'am, typically what happens is in a mediation, both parties will sign an agreement that says this is what's going to happen. And it sounds to me like you guys came to that agreement, and it's typically reduced to writing. Once it's reduced to writing, then both parties have the ability to force the other one to comply with it if they don't. And then the mediator files a notice with the court that there was a settlement. Sometimes a copy of the settlement agreement is filed with the court, sometimes it is not. It doesn't have to be, but sometimes it is, sometimes it is not. If the parties have complied with everything and there's no reason to file anything else, then it is reasonable to just file a notice of dismissal because the parties have settled. And that is a very common thing. The parties come to an agreement and then they file a dismissal. Usually, however, the dismissal is not filed until after all the parties have complied with their respective obligations under that agreement. So to answer your question, what is normal? Normally, there will be a signed agreement between the parties. Each party gets a copy and they have to comply. Normally, the mediator would file a notice of settlement, and then it would be up to the parties after they've complied with their obligations for one person or the other to file their notice of dismissal so long as the obligations have been complied with. Once you sign that notice of dismissal, you effectively agreed that everything had been complied with and that the case was done. Does that answer your question?
No, yeah, it does. Yes, ma'am. It does.
Okay.
Yeah, it
All
does.
right.
But I need to study maybe to get the license to become an attorney.
Well,
I don't have those
we
problems.
only,
You know?
we only have 120,000 attorneys in Florida, so,
I think that's what it is.
all right.
All right, we're gonna actually
Thank
circle
you.
back to Carmelita because we did skip her. So Carmelita, you're next.
Yeah, I did call Carmelita, but I think this lady thought it was her.
Yeah, that's okay. Carmelita, you can unmute yourself.
Can you hear me?
Yep.
Yes, ma'am.
Okay. I have a small claim filed and I did everything. I paid about over 2,000 court fee to get my money because I had a car accident, but the judge could not help me to collect the money. And I have a Zoom meeting, but the judge could not help me to collect the money. But the dependent, he joined the army. Is there possible that I'll be able to collect the money?
Mary Ann, you want to?
That's going to be a tough one because it's very hard to garnish wages for someone who's in the military.
Correct. So I would not be able to get that money then. I paid all the court fee for over 2,000. The accident repair job was 2,000. Plus I spent 2,500 for all the paper document in court.
So Ms. Carmelita, if you have a judgment, you can record that with the state of Florida at sunbiz.org, sunbiz.org. You can record your judgment with them, and that judgment will be on file for the entire state of Florida. And you can also record it with the county in which you received it. That judgment is good for 7 years, and you can renew it at the end of 7 years, so that that judgment will stay on the record with the state of the individual that you got the judgment from. Now, if at some point they purchase a home or anything else in the state of Florida, and then they turn around and sell it, that lien will be there and that would have to be paid as part of the closing on that sale of that home. That is one way that people can collect. They just have to wait a good little while for it to happen. As far as going after the individual through something like a garnishment of wages, I don't know enough about the military process, but the last time I tried to do something was many years ago, and I don't know, it may have changed by now, but I don't believe that the military allows it. They might, and you may find information on the military's website. They have a financial Department of Financial and something division where you can ask questions like that of the military and whether or not there's a process for it. But I do not know of the specific process, but it would be called a garnishment of their wages, I think is what you're trying to do. Once you get the judgment, that's how you would go about trying to collect it.
I just like to add, I think, Marianne, that the time of the lien is actually 10 years. And you can renew it before the 10 years are up. It's not 7.
Okay.
And as far as the, how do you know he's in the military?
We used to work together at Disney. And I talked to one of his co-worker and I asked him about him and he told me, oh, he joined the military in the army. He's in Georgia.
Yeah, yeah.
And I did try the military. Someone from military, he could not help me. Right.
You know, it is complex. This, yes, I haven't even done it myself. I think it's Soldiers Military Relief Act is called, something like that. If you are interested, you can make like a consultation with the self-help, center that they have there at the courthouse, and the lawyer can check into that for you. So that would be another avenue to get what you want.
Okay, can I get that website that she was talking about? I could not write very fast, where I can record the debt.
That is with the state of Florida. It is S as in Sam, UN, B as in boy, IZ .org, sunbiz.org. That's the state of Florida secretary website where you can get information on how to record a judgment.
Oh, okay. Yes, I just want to collect the money, but I could not. I spent all my money,
And if you want advice about the self-help center, I think Rebecca here from the library, I think she's going to send, Rebecca, can you tell her? Are you going to send information about that?
Yes, I'm going to send information about the Florida, the Bar Association and lawyer referral and self-help center.
Oh,
okay.
I did contact one lawyer. Nobody want to take my case because it's already filed. I already did, and no one can help me to collect the money. They want to start from the beginning so they can make money.
So Carmelita, it may not even be that. It may be that it's going to cost you more money to hire a lawyer to figure out how to collect the money than it's worth. And most good lawyers will tell you that. If you've got a judgment of $5,000, you might spend $10,000 or $12,000 trying to collect it just because of the process. And so there's no point in you doing that. And I will tell you that I just looked up the Service Members Civil Relief Act. It used to be called the Soldiers and Sailors Civil Relief Act. If you go online and you can look up the Service Members Civil Relief Act, just do a Google search for it, and it will tell you what the benefits are for people who are in the military. And you might actually answer your question that way. But you can also talk to the Orange County Bar and see if you can get a referral to talk to an attorney who knows a little bit more about it than we do. But it would be the Service Members Civil Relief Act. And basically what it does, it prevents them from being sued for certain things while they're in the military and for up to a year after active duty. but it's very complicated and what can be done and what can't be done. And I'm not qualified to answer a question any more than tell you to where to go to look for that information.
Do you mind if shoot me the email Soldier Relief Act? Soldier Relief Act.
Just do a Google search for Service Members Civil Relief Act. Service Members Civil Relief Act.
Okay. All right. All
Okay.
right. I got that. Yeah. All right then. Thank you so much.
You're
Good luck
welcome.
to you, ma'am. All right, did we skip over anybody else?
No,
Yeah.
we're now on PW Kirsch, I
All
believe.
right, PW Kirsch. I see the question, what are the most common small claims and consumer law matters in Orange County? How can I avoid being a victim? And I want to avoid the legal system if possible. Don't we all? Sometimes you really can't avoid trouble. Sometimes it just happens and, sometimes you can't avoid that. I think Candace would probably be the best person to answer what are some of the most common small claims and consumer law matters. I know from things that I handle, small claims, most of them are contract issues between individuals, trying to get money for something or trying to get a refund, and similar to what we heard earlier. But the consumer law matters, they run the gambit from, automobile repairs and landlord tenant matters to lemon law issues. I mean, they kind of run the gamut.
Marianne, what was the question? I didn't get it. What was it?
What are the most common small claims and or consumer law matters in Orange County, and how can I avoid being a victim?
How can I avoid being a victim?
Mhm.
Okay. Yes, I agree. It's many things, anything you can think of, basically. Of course, like divorce, for example, that would not be consumer law,
Right.
but many things.
Well, as I was talking to Rebecca earlier, there is a website that the Florida Bar puts out for the public and consumers. And they have 46 different pamphlets for consumer protection issues. So I don't know what the most common consumer law matters are here in Orange County, but I will tell you there are 46 pamphlets on the Florida Bar website. And so that's a lot of issues. I think in the last year, some of the most common things that I've seen have been the construction related issues from contractors not doing the work that they're supposed to do, roofing contractors in particular, showing up, not doing the work, but they get the money up front and then they don't come back and they just take the money. So I think that's the biggest complaint I personally have seen in the last 2 years. And different kinds of fraud, how people misrepresented things and others got taken advantage of by that. So PW Kirsch, does that answer your question? I don't see a thumbs up or a thumbs down.
Yes, he says.
Yes, okay. All
Thank
right.
you.
All right, so who is next? Looks like Frank. Is the small claims judge supposed to follow standard accounting rules when declaring which reimbursements are chosen by the judge instead of just providing a total? My case judge did not provide an itemized list of reimbursements that were awarded in my case, and that makes no sense to me. I have no idea what she reimbursed and what was not and why not. You want to tackle that one, Lewis?
You're gonna have to repeat it for me because I'm not seeing that question anyway.
Yeah, in the chat room, it says, it's right under PW Kirsch.
Let me see.
You may have to scroll up a little bit.
I don't see it. I don't see it. I'm sorry.
Look at the timestamp. It's 5:45 p.m. was this timestamp.
5:45?
Mhm.
Okay. Oh, I think I found it. Let's see. Is the small claims judge supposed to follow standard accounting rules when declaring which reimbursements are chosen by the judge instead of, well, I know the judge doesn't have to follow standard accounting rules, I'll tell you that. My case judge did not provide an itemized list of reimbursement that were awarded in my case, and that makes no sense to me. I have no idea what she reimbursed and was not. Why not? Yeah, I don't think there's any requirement that she give you a itemized list. That would be my answer.
And Frank, if you do want an itemized list, then what you would need to do is file a motion for clarification, asking the court to provide you that itemized list. They don't have to, but if you want it, the only way you could potentially get it is to file a motion for clarification, asking the court to provide that.
I agree, or we call it a rehearing too. I think you only have 10 days, okay? So be aware of the timeline.
Yeah. All right, we already answered Miss Carolina's question.
Sorry, Frank, it's still your turn if you had a question. I see your hand is still raised.
Oh,
Hello.
Right. Hi, we can hear you.
Yes, I did file for clarification and I did not get a response back for that. Instead, they had replaced the judge and it went to a different judge, and he called some meeting and claimed that I was trying to ask for more money than what I was reimbursed. But again, I had no documentation that said what was reimbursed and what was not. Is this a failure by the judge's office and I should get my money back for the court?
Did the judge enter another order from the last time you went to see him?
What do you mean?
Did he sign another paper saying that you were looking for more money or anything like that?
Yes.
Okay, so I guess he's not. You could file another rehearing, but I don't think that's going to work because it will be a rehearing from a rehearing. You're talking then about maybe an appeal. I'm a loss of what else, Marianne.
But this is some kind of gray area that just gets blown out of the water and I get no representation from a judge or anybody else.
well, the judge can't represent you though, Frank. The judge cannot represent anybody. They're not a lawyer that can represent you. That's why they're the judge. So
what I was saying, I'm saying, is there not somebody that watches these judges to make sure they do their jobs or not?
well, we're not even sure that the judge didn't do their job because they did a reimbursement. You're just asking for a clarification on what the amount was and for what. There's nothing that requires the court to do that. Now, certainly if somebody wants to make a complaint about a judge, there is a process to do that. It has to go through the Judicial Qualifications Commission.
I did that also.
Okay, but it sounds like you did what your options were, and I don't know that there's anything else that we could tell you.
Well, I think, you did the right thing. You filed a motion for clarification. The judge heard you. He decided that he had no merits, and then, that's the end of that. Now, you say, well, is there anything to protect us? And the answer is actually yes, because you could have a court reporter and you could have a lawyer. I understand these are unrealistic things, but, I'm just trying to answer your question. There are ways to protect yourself, which is having a court reporter and having a lawyer and then appealing it to the next level of the court, which, by the way, all of that costs a lot of money. But that's how we control the judges, by having a record being made. And then sometimes they are scolded by the judges upstairs. I am referring to appellate judges, but that's how they are controlled. And like Marianne says, if you feel that he did something wrong, like out of line, then you can also deal with the Judicial Commission. But that's how we lawyers deal with problematic judges, by having a record and then appealing it to the next level.
Yeah.
Yes.
Most of the attorneys will pay to have a court reporter present during the hearings. So that if we need to have a transcript of what happened and ask the court to enter an order based on what was said, you'll have that. But if you haven't brought a court reporter in or don't have some other, recording device by which to do that officially, there's really not much else you can do.
Yeah, is there not something that can happen beforehand so that somebody like me wouldn't have that same mistake the next time?
Well, I don't know how you could do that because every case is different.
Then why isn't there some kind of reimbursement when it isn't followed properly? It just seems like a money trap. So anyway, I'm just trying to.
Well, remember, there's also many types of judges, so it depends on your judge too.
I understand.
Some of them may go the extra mile to be polite and accommodating, and some of them will not. And
Well, this was a
Yeah.
bank transaction, so it seemed like she was partial to the bank and not to the general client that was shorted by the bank. But I appreciate the answer.
all right, take care.
All right, so who is next?
Anna, you are next.
Anna? Can you unmute?
Excuse me, sorry. I'm Luis Marquez. Ana is my daughter. Apparently, this is her account. That's why Ana is showing.
Okay, what is your name?
Luis Marquez. Luis.
All right.
I had a question. 2 years ago, I purchased a home through a foreclosure procedure, and the home came with an HOA debt of about $6,000. As soon as I took possession of the home, I sent the HOA the certificate of title and asked them to give me a payoff amount and offered to pay as soon as possible. For some reason, the HOA ignored my request, even though I made that request several times for the payoff amount, and they moved to foreclose on the property, even though I sent the certificate of title repeatedly and requested them for a payoff amount. Eventually, I talked to several attorneys, and they said that it was such a small matter that it wasn't worth their time or the money, and I couldn't find representation to do anything.
Yeah.
I ventured to send $500 to see what happened, and immediately, as soon as they got $500, they stopped the process. But they say I had incurred about $2,000 or $2,200 in attorney's fees. So even though I paid the debt when they told me, they still charged me with unnecessary attorney's fees because when I offered to pay at first, there was nothing going on in court. I was wondering if there's anything I could do. This was 2 years ago. I think the statute of limitations is like 4 years, but I'm not sure.
So I'm not sure I understand exactly your question, Louis.
Okay.
Let me see if I can figure it out. Did you ultimately pay the $6,000?
Yes, I did.
Okay, and when you paid that, was it before or after they filed the foreclosure?
After.
Okay, so when you paid that, what they're asking for is the additional $2,200 for the attorney's fees that were incurred for them having to file the foreclosure action, correct?
Yes, that's right. I actually paid the whole thing already.
Okay, and what you want to know is there any way for you to get any of that $2,200 back? Because why did they file a foreclosure when you'd offered to pay it? Were you asking for the payoff? Is that right?
Exactly. I offered to pay before they started any legal process to foreclose, and they went ahead like maybe 30 days after I offered to pay. They kept going with the process, and they wouldn't listen to me that I wanted to pay.
All right, well, I think it's going to depend on what you have in writing, first of all, and how they perceived that and how they proceeded on that. And whether or not you can get the $2,200 back. Now, there's a question in my mind as to whether or not you had any assistance. Like, did you go to the Orange County Bar Association Citizens Dispute Settlement Group to see if they could help mediate a resolution on this?
No, this is the first time I ever heard of that.
Okay.
I tried different attorneys, and they basically said that just pay it. It's not worth the time or the money.
Well,
I
that,
was trying to pay, but I couldn't pay. They wouldn't take my money, basically.
well, so there's a thing there's a legal term, it's called tender of payment. And what that means is you pay the money that is owed. And once you pay that money, you've tendered it over, and therefore the matter is concluded. But tender of payment doesn't end with just a payment of a check, okay? Because the check hasn't been cashed. So until that check is actually cashed, then there's been no tender of that payment. So even if you had sent them a check for $6,000 and said, is there anything else that's owed? They might have cashed the check, and then that part would have been tendered and been done. And they wouldn't necessarily have been entitled to any attorney's fees to collect on that because you'd already paid it. And then the request for, is there anything else that's owed? That should have come as a separate part, because that would have been something beyond what was originally requested in the lawsuit that led to the foreclosure. So at this point, you're 2 years out, and I don't know, this isn't necessarily a contract action, it might be a negligence action. I don't know. I don't, honestly, I agree with the other lawyers. It's just not worth it. I mean, if you want to hire a lawyer to help you try to recover $2,200, you're going to spend 10 times that, and it's just not worth it. Now, if you want to try to resolve it through a mediation and see if the citizens dispute can help you with that or get any of that money back, and you've got documentation saying, look, this is how many times I requested it before you filed the foreclosure. Why do I have to pay money now when, or, why did you require me to pay money when I shouldn't have? But you've already paid it. So I don't know how that's going to go for you.
Yeah, that's what I got from everybody, basically. I do have a log of that was provided by the HOA stating when they sent the case to the lawyers, which was pretty much a month later after I offered to pay, and explaining how all the charges by the attorneys were progressing, like like an hour here for this, an hour. I kept adding up,
Right.
even though I kept insisting that I wanted to pay, and they would do nothing. So I guess, yeah, it might be negligence.
Yeah, I
But
don't know.
nobody could tell me what to do, basically.
Yeah, it really is a matter of, if you've got documentation saying, I asked for a payoff, I asked for a payoff, I asked for a payoff, and they never gave me a payoff, they can turn around and say, look, you knew what the payoff was because it was in the, there was $6,000. That's what the judgment was. You could have just paid that and been done. And they might also say, and then when you ask for, is there anything else? We didn't tell you what was left because we hadn't calculated. I don't know. There's a couple of moving parts here that we don't really have the answers to. I just know that it's 2 years down the road and it's additional accounting issues, and I don't know. You may want to try to see if you can get them to the table through citizens dispute for mediation, see if you can recover any of it, but I don't know that you have any legal grounds at this point to try to recover it. I don't know.
Okay, if I did try something like that, would I be exposed to having to pay the other part, the defendant's legal costs because I don't succeed?
Typically in the citizens dispute, everybody pays their own way. They pay their own, legal fees and that sort of thing. So you could ask them that when you call them. There may be a different rule, but usually it's the parties pay themselves.
And it is a process outside the court. So,
Right.
So no, they shouldn't charge you for that.
Okay, so how do you
And
call that?
it's also, sorry to
Yes.
interrupt you, but it's also voluntary. So they may just tell you, no, we're not gonna do it.
What's the name of the department?
It's the Orange County Bar Association's Citizens Dispute Settlement Program. If you call the Orange County Bar and ask about how to set up a mediation with an HOA, they'll get you to the right place.
Okay. I actually did run a couple of things by the Bar Association, but I wasn't very successful getting answers or help.
Well, we wish you the best and thanks for calling in tonight.
Thank you.
All right.
All right, next is Kathy. You can go ahead and unmute yourself.
Okay, can you hear me?
Yes, ma'am.
Great. First, I want to start out and say thank you very much. I'm so grateful that you are doing this. So thanks. My credit was great, and I had used charge cards and paid them off always. But unfortunately, I had to have surgery, and it really got botched up because I can't walk anymore. I use a walker and I can't work. I was taking care of older people and had quite a few cases I had to give up. So the bills, my income, my Social Security is really very small. I had hoped to subsidize it with working, but that's something I can't do. So one company is taking me to court. I wondered if someone told me I probably don't have anything to worry about because I don't really have anything.
Mhm.
But then I have a car, so now I'm really confused. It's I use it. People take me out, will do things. I don't have to worry about it. It's I'm not ready to get rid of it. I wanna-
So you're concerned whether they can take your car?
Yeah, do I have to worry about it because I
Mhm.
really don't have 50 cents a month to give them.
No, I don't think you need to, but how old are you, if you don't mind? So we need to
70.
know.
No, I don't
So-
mind 70.
Okay,
I live
so,
in HUD housing.
yeah, no, I think you are fine because you are what we call judgment proof. And they cannot take your Social Security. They really, if they were to sue you, they're not gonna recover anything. So they're gonna just spin their wheels. So the only thing is, they may call you and try to collect from you. I don't know have they already sued you?
There's on August 2nd, I have a virtual
Okay. All right. Well, you just tell me you can't pay. You're 70 and all you get is Social Security. And there's really nothing that you have to worry about other than your credit. And at 70, probably your credit is probably already affected anyway, because you fell behind.
Yes.
So no, you don't have to worry about anything, is my opinion. Yeah.
Kathy, how much is the debt?
About 1,200, but I have a few other cards as well. I don't know if they're going to come after me.
Okay.
I try to tell people, but they just don't give up.
They don't. And so there are some debt consolidation options where you would pay one company and then they would pay the others, a certain amount. And I don't know if you would qualify for bankruptcy because I don't know what your income to debt ratio is. I don't know if you have a mortgage on your home, that sort of thing. So, but generally speaking, your home is safe from creditors.
I live in HUD housing, so my rent is according to my income.
Okay.
So I don't pay very much.
Yeah.
So
So
it must be here.
yeah, I agree with Louis that I think if you go into, wherever it is, and if they want to get a judgment against you, well, they still have to find a way to collect, but how are they going to collect? Are they going to, Louis, I don't think they can attach Social Security, can they?
No.
Okay, so they can't attach Social Security.
That's comforting. Thank you.
So
No,
if you don't have
definitely
any other
not.
income for them to attach, they could try to find a bank account, but if you don't have any money in your bank account, then, it's just, yeah.
And you know, finding out bank accounts, I don't think, I mean, I tried, so I asked the people, let's say my investigator, you can't find bank accounts easy that I know of, who has what anyway, so.
Well, that helps a lot. Thank you. Could I ask one other quick question? Is when I was in the hospital, I trusted someone to take care of things for me. She had been helping me. And only to get out and realize she really took a lot of stuff. The detective did find some of my jewelry, but a lot's still missing. And it took a lot of cash, things that she did get work. She was on probation for stealing. She did get a couple of years more because of what happened to me. But is there, will I be able to get something in small claims? Is it worth it if I can't prove it? She took a lot.
Well, yeah, I think you just answered your question. If you cannot prove it, you're not gonna get it.
Right. Yeah.
I see. Okay. Thank you. Thank you so much.
Thanks
You're
for
welcome.
calling in, Kathy. All right.
All
who's
right. Next, we have iPhone Nelson.
iPhone 185 Nelson, what's your question?
You can unmute yourself. All right, one more last call for iPhone Nelson. If you want to go ahead and unmute yourself. All right, we can come back to you later. You can, I'm going to lower your hand. You can raise it again if you come back. All right, next we have Carmelita. Did you have another question?
I think that was the original one. I think we just,
Oh, okay. Let's see. PW Kirsch, do you have another question? Oh, it's in the chat. Can you tape record the small claims and or hearing processes and or mediation? Do you need official permission?
Yeah, you need official permission. I mean, I don't think it's even allowed, period. You can't do that.
Okay,
I never heard of that.
perfect.
well, there's no court reporter that is provided in most small claims cases. If I do a small claims case, I always take a court reporter with me. If someone wants to record it with their own tape recorder, they would need to get the judge's permission to do that. But then typically what would happen if they want to use that as an official recording, then they would have to turn that over to the court so that the clerk could have it in case it ever needed to be transcribed. So then they would lose that. All right.
All right, the next question I'm actually going to ask anonymously. So someone is having an issue with someone talking bad about them on social media, destroying their reputation, calling them a murderer, and can they sue for character defamation?
Yeah, you can, but the problem there is, number one, that may not be a small claims case. It's certainly not consumer case. That is a torts case. The problem with those cases, I haven't done one, being honest, is that you have to prove the damages of how your reputation has been harmed. You know, so that is difficult to do. Marianne, you want to add anything, please?
So there are a lot of issues here. It's kind of like a bad law school question. You don't realize how many issues there are until you start talking about it. So with social media, there are so many ways for people to hack your social media accounts, to clone them, to make it look like it's you when it's not, make it look like it's somebody else when it's not. So the problem with proof on social media is you first of all have to prove who the person is that is doing this, and that it's not someone else, or that your account hasn't been cloned and there's an anonymous person, IP addresses and that sort of thing, which requires a lot of technological ability to be able to get that information. So that's the first thing. And in order to subpoena records from one of the social media companies, let me just say it's as attorneys, we face an uphill battle all the time. And there are certain companies that absolutely will not provide any information at all, even with a subpoena. So, trying to subpoena records from, say, Facebook or Snapchat as to, who owns a certain account and when was it set up, good luck getting that, because even the attorneys have a difficult time getting that. They keep that stuff very, tight and confidential. So those are the first two big problems if someone is doing that. Now, if it's a bullying issue, which of course would be a defamation or a tort, if it's a juvenile, it may be something that could be addressed if they know it's someone at the school that can be potentially addressed through the school. So again, I don't know if anonymous is an adult or a minor, but I throw that out there in the event that the victim is a minor. Another option is to contact law enforcement. There may be a crime here. It may be cyber stalking. It may be cyberbullying. And if that's the case, it is a crime, and law enforcement could investigate and get involved in that, potentially give you some assistance. They have much better luck getting subpoenas answered when it comes through a law enforcement agency in a court order that way. So that is a third option. Now, the other option is to shut down the account, period. Just shut down the account.
I do have a little bit more information if that helps. So it is a familiar person, and it's an adult. They have proof, and there is some like assault involved that might be the reasoning behind. Like there's something else going on that could be the reason why this is happening. So it's someone familiar.
What do you mean, like something else going on? I mean, has she been assaulted or something?
Or
I can tell you guys more. If that's
Hi.
okay.
Yes, you can go ahead and speak.
Hi. So my husband assaulted my daughter, and his mom is just in social media bashing me out, calling me murderer, saying a lot of things about me, and I have proof of it. That it's coming from her Facebook, and she's the one doing it. She even tried to get my other son, went to court and tried to get guardianship. And in the paper, she's saying that I abused my son, and it's a lot of things.
Is she sending you emails directly to you or posting in your Facebook account?
She posted on her account, and she posted my picture with it. And she also did a forced allegation in court to get my son away from me, to get guardianship.
Yeah.
I think all of this is leading towards a more criminal aspect, Louis, don't you?
What about like stalking? I don't know, maybe stalking is not correct because it's not directed to her, it's, to other people. But it may be a possible option. Now, what we mean here is that you go down to the courthouse and file what we call an injunction, which is an order, a restraining order from her keeping doing this, which from what you describe, I mean, it's pretty bad harassment. Yeah, putting your picture in her Facebook account. I mean, that is pretty bad, and calling you a murderer. It is also using violating your privacy, and that is something legal as well. But then you get into also what I said before, which is you need to prove you've been damaged. I didn't explain that to you. And damage means how you have been how you lost money because of this woman's action. But if she's harassing you, then you may want to go down to the third floor at the courthouse and file an injunction because this woman is your mother-in-law, whoever she is harassing you, and hopefully the judge will grant that. There is something called cyber stalking. I believe I read a case because we're always reading cases that it has to be directed to you. And that's why I asked you if she was sending you the emails. If she posted in her Facebook account, that may not cut it, but I mean, you may still get it. I mean, that the judge may still grant it to you because it sounds pretty bad to me.
So, yeah, so you do have some civil overtones here. You have some criminal overtones, ma'am. And if this is, if it's harassment to the point where you are suffering from some sort of monetary damages, and that could include you have to go to the doctor and get antidepressants. And because of this, it's getting to you so badly emotionally. If it's that egregious, then there may be some money damages based on what you have to spend in order to keep yourself, in a place where you can handle everything. I don't know, but if you seek an injunction to try to stop these things from happening, then that is the civil action. That's the way you would do it civilly. It could be harassment. It could be, there's a tort, it's called false light. It could be just simple defamation. There are lots of things it could be, but there's also criminal things that it could be. So you may want to consider filing an injunction to try to stop it. You may want to contact law enforcement and see if what is happening rises to the level of a crime, because if so, then they could investigate it and potentially do something for you.
Let me ask you, and this is just kind of like, but it is relevant. Does your mother-in-law, whoever this lady is, does she have assets? I mean, is she wealthy, or does she have a good economic, position? Is she still there?
Sylvie, I think we lost you for a second. Do you mind asking that question one more time, Louis?
Yes. Does the lady who is harming you, does she have assets or money or houses, or does she have property? She's in a good economic position.
Yes.
She does.
Yes.
Okay. Well, it could be like intentional infliction of distress. So you can call like one of these lawyers, like Morgan and Morgan, and explain that these people, this lady is doing this. And if she has assets, they may go after her without charging you. Because if she's doing this intentionally and it's causing you all this stress, that is a legal violation as well. And they may not charge.
It's very frustrated because
right.
Not only I'm dealing with what happened to my daughter, and I lost a daughter last year, and then now this. So
right.
It's taking a toll.
Right, but I'll tell you, unless this lady has substantial assets, they're probably not going to bother. So make sure that, so if she doesn't have much, you're wasting your time. But if she does have assets, they may take the case for you without charging you.
Okay.
All right, who's next?
Okay, thank you. Thank you so
You're
much.
welcome. You're welcome.
You got now, right?
Right.
All right. We have Rosier.
Rozier?
Yes. Can you hear me?
Yes, sir.
Okay. Well, I currently have a case that is, I want to say family, as well as with the Department of Revenue. And I wanted to know, it's kind of like a two-ended question. One, is it possible to show details or bring to the courts that the services of the Department of Revenue are being used vindictively? And if so, how would I be able to do that?
Well, I'll just say that's not a small claims nor a consumer question, so we shouldn't be asking that question. I will refer you to the lawyer referral service with the Orange County Bar. They're gonna share an email and ask for say a family law attorney. You know, it's probably the best avenue, I think, for you.
I agree.
Okay. And I think that was where most of my questions were probably loaded, more of a family court type deal, not consumers claims. And I do appreciate you guys' time.
Yeah.
Thank
But
you.
get a referral for a family law attorney from the Orange County Bar and see if they can help you.
Okay.
All right. All right, next question is with who?
Let's see. I don't have anyone else written down. PW Kirsch, did you want to ask any questions specifically? Or if anyone else has any questions, feel free to raise your hand or you can type in the chat. Carmelita, did you want to go ahead and ask your question?
Can you hear me?
Yes, ma'am.
Can the Motor Vehicle Bureau in Tallahassee, can you hear me?
Yes, we can hear you.
Okay. Can they revoke if I have the judgment? Can they revoke the driving privilege of this dependent?
What kind of case was it?
Small claim.
Yeah, but what did you sue him for? What?
Accident. Automobile accident.
Yes, yes. It could be cancel his driving privileges. This is in the only type of case when you have a judgment in a car accident. You can cancel his license until he pays you. It is possible. So you can contact the motor vehicle department and ask him how to do that. So it is possible, yes.
And also, another question is, how long is my small claim be good for? I started it last year because my accident was October 2021.
When did you get your judgment?
My judgment was just recently. I think was hold on.
More or less, March?
April 13th.
You got 10 years, you got 20 years to collect.
I got 20 years.
Yes.
And how often do I have to renew?
You don't have to renew for 20 years, but if you, I think at the beginning we're talking about recording a lien. The lien will prevent the defendant from buying or selling real estate. That one lasts for 10 years and you have to renew it before the 10 years are up for another 10.
Okay, but the small claim in the court, at the courthouse, I don't have to go down there every year.
No.
Oh, okay, all right.
No.
Well, thank you so much for doing it.
Thank you.
Okay, so we have two questions from PW Kirsch. You mentioned that fraud in contracts are a big issue in Orange County, Florida. What should people be aware of when dealing with LLCs?
We're dealing with what?
LLCs, limited liability companies.
Limited company?
Well, I don't know that it's just a matter of limited liability companies. It's in dealing with any company, especially when we're talking about things like these roofing issues and construction issues. What you need to know is, are they licensed to do the work that they are trying to do? Are they required to be licensed to do the work they're trying to do? In construction, there are certain areas where they have to be licensed by the construction board from the state, and then there are others that are not. And so you may also want to find out if they have a, business license as well as the professional license. I mean, if you're going to be an appraiser, you certainly have to go through school and you have to have a special license, just like lawyers. So I don't think it's just limited liability companies. It's any company or any individual. You want some evidence that they know what they're doing, when they're going to do it. You have some sort of recourse. If you're going to sign a contract with them, you shouldn't be paying everything up front because then they're just going to walk away with your money. There should be some way to have recourse against them that could be placed in your contract. So it's not really a matter of things to be aware of with LLCs. It's how do you deal with people in general? And you get it in writing. You get everything in writing to the best of your ability. And if they take money and they walk away and they don't do work, then you can also go to law enforcement and see if they will do a theft report and, charge them with theft. But it really comes down to, did you get it in writing? What were the terms? What did you agree to? And how do you protect your interests? And so just go through the what ifs. What if this happens? How do I protect myself? What if
I'll sorry to say this, Marianne, but one big issue with fraud, anybody who comes to your door and knocks on your door, don't do business with them. Normally, this is fraud. This is a red flag that they're targeting you for a reason. Right. So do not, in my opinion, don't do any business with anybody who comes soliciting to your door at your home. I'm talking specifically residential. And I agree with Marianne. Read the contract before you sign anything. I mean, I saw a lady the other day. She was buying a house for almost $300,000. The contract was at least 20 pages. And, and the builder was not responding, let me put it that way. And so that was a big mistake. I mean, the bigger the transaction, they should be done by a lawyer. They should be read by a lawyer before you sign in the dotted line. Because if this builder doesn't continue working, she has very limited avenues. She already sold her house that she had. So, she almost has no recourse other than paying a lot of money to a lawyer for an uncertain outcome. So the moral of the story is nip it in the bud. Get it done before you get into the deal, is what I would say.
I will leave everyone with this one piece of advice that I tell all of my clients and potential clients. If you have to sign a contract for some sort of business deal that you are undertaking, and the contract that you're signing or the paper that you're signing or the paper that you are requested to sign means that you will be responsible for more than $500 worth of anything, then you need to spend $300 and have an attorney review that paper for you. So I don't care if you're trying to sell a business, if you're trying to buy a business, selling a house, buying a house, selling a dog, buying kittens, it doesn't matter. If you're signing a piece of paper and you're on the hook for more than $500, you should have an attorney review it and spend the $300 to have an attorney review it, period, end. Because you're going to save yourself a lot of hassle down the road. And Louis and I have both probably saved a lot of people a lot of time and effort keeping them out of harm's way because we reviewed something for them and said, this is not good, this is not good, this is not good. You're going to find yourself in a real bad place if you do this, because if this goes south, you don't have any options. I don't recommend that you do this. I'd rather see you spend the money up front, talk to an attorney about it, than on the tail end going, how can I get my money back? And, an attorney says, it's $3,000. It's not worth it to us to take on a $3,000 case.
I second that.
All right. Who else do we have?
Martha, if I don't know if you want to unmute yourself, but I will go ahead and ask your question. What are the key foundations when making a business contract?
Well, the terms of any contract are going to be individual to the people who are making them. You know, you always want to know the who, what, when, where, why, and how. You got to start there. Who's going to do, what are they going to do, where are they going to do it, how are they going to do it, when are they going to do it, what's it going to cost? Okay. So the terms of any contract should always involve the first few things: who, what, when, where, why, and how. And then once you get into those, then you're going to break it down even more. So if one of the terms of the contract is you're going to buy a used car for $5,000. Okay, well, who are you going to buy it from? Where are you going to pick it up? When are you going to pick it up? How are you going to pay for it? Are you going to have to get a loan for it? What are the terms of the loan? What's the interest rate? Where's it going to come from? I mean, there are a lot of later questions that you need to ask yourself, but the very first thing in any contract should be who, what, when, where, why, and how.
And I would actually tell you that you need a lawyer. You know, you need a lawyer to do it for you, because I've seen so many handwritten contracts or prepared by somebody else, or that are just, you know, they're just not worth the paper it's written in, basically. So, and when you mention business, you know, that tends to be even more complicated. So get a lawyer and prepare it for you is my advice. Yeah.
And at the very least, if they insist on doing it themselves, have a lawyer review it.
That's right.
Before you send it out and before you commit to anything.
Which probably is going to cost you about the same than the lawyer preparing it anyway. So, you know, so you might as well have the lawyer do it anyway.
Okay, so I'm barely gonna start a business, so I basically wanted to know the foundations of how to build a contract. Like you mentioned how I've heard situations from people that been in situations where the customer doesn't pay out. And so how would I put that in a contract that's visible, that defends my line of work of what I'm doing? Because I thought, let's say for instance, right, for example, I'm an electrician, I'm starting a business, and I got this commercial job, right? And they're only accepting, let's say the estimate is like 30,000, let's say, and they only want 2 parts within the estimate. Can you use the estimate as a form of a business contract?
Yes, you can use the estimate as a form of, you can even use an invoice, because I've seen invoices be a contract. So
There's got to have a lot of other stuff in it too.
Yes, yes, exactly. I would consult with a business law attorney to get your business going.
Yes.
With the Orange County Bar Association here. And number 2, you know, that's not even really a consumer question. That's really a business question. But yeah, I would check with before you do your business, check with a business law attorney. You know, you're starting a business, you said, right?
Correct. I guess I just don't want to have any type of issues with the customer if I do the work, because I've heard situation from both ends. Like the customer doesn't get what they're needed because, you know, the person of the business wasn't licensed, wasn't insured, or so on and so forth, right? And I've also heard situations where there's customers that don't pay, or they just be like, oh, well, you didn't do your job, so correct me, so I'm not
if I
gonna
may
pay you.
ask you, what kind of business are you planning to open?
For myself, it's gonna be an electrician.
Electrician.
Mm-hmm.
Yeah. The best advice I can.
Talk to a lawyer. This is not.
Yeah, the business law attorney. Yes.
Yeah, this is not the right forum for us to talk to you about that. There are so many nuances to starting a business, and I'm one of those people. I help people start their businesses. I help write their contracts, And oftentimes their contracts change over time when issues come up and they say, oh, this happened. Now we got to do something else to the contract to protect that particular interest. You really need to have a business law attorney. Do not go this alone. You are just asking for trouble if you try to go it alone. Just get a referral for a business law attorney from the Orange County Bar.
Which are free, by the way, so you're not going to spend anything in the consultation. So.
Okay. I see. So then my following question is, I think you did mention it, but how would, as far as for me as a business, a small business that's going to start, how would I input in the contract if whatever case scenario, if they're not satisfied, that I will still have to
Your
get
attorney
paid,
would
or how
have-
does that work?
Now, that's something that is special language that an attorney can help you do. And it is very special language, and it is very dependent on the type of business you are in, whether it's services, whether it's products. It's very specialized.
Yes, and don't wait to get burned to get a lawyer. Do it now.
No, no, absolutely. That's why I was trying to
Yeah.
prevent myself from this for any type of
Two
situation.
attorneys are telling you, check with a lawyer. We're not saying this because we like to talk. Okay, so please be prudent and get your consultation for free with a business law attorney. That's what you need to do.
Yes, absolutely. All right, Olga?
I'm so sorry. I just want to re-clarify. Would this be with the Bar Association, or would I have to like look in depth because it's a particular
No,
side
the
of
bar,
attorneys?
the bar association is gonna, my understanding, they're gonna send you an email at the end with the bar association, the lawyer referral number, and ask for a business law attorney. You can ask for maybe also a corporation attorney, but you know, either one of those would be good.
Okay. Now, as far as like maybe you guys know, as far as the EIN number,
Through the IRS,
No,
go to the irs.gov website, and you can set up an EIN number. It's very easy.
Oh, okay. So as far as like negotiating like prices is concerned, is that negotiated with the consumer and the business? Or do you think that has to be like a straightforward, like let's say for roofers, it's like 50%. And as far as like other businesses, that it could be negotiated.
It can be negotiated, as far as I know, just like we lawyers, we can charge basic, well, you know, we do have some limits, but again, you know, check with an attorney. But yeah, you can negotiate, as far as I know, any price you want to, as I know.
Okay, thank you so much.
You're welcome.
I appreciate your time.
You're welcome.
All right, Olga, this is your chance if you'd like to unmute yourself. Olga, can you hear us? I feel like I saw you trying to unmute yourself. I'll give you one more second, Olga, if you would like to unmute yourself. All right, that does conclude today's event. Thank you so much to our speakers. We appreciate your time in helping us with those questions. You guys did a great job, and we appreciate your expertise. Thank you so much for being here tonight. I want to thank the Orange County Bar Association for putting this together. Miriam, did you have a conclusion that you wanted to say?
I did. I wanted to say again, thank you for attending the Ask a Lawyer event. We do these regularly because we really do want to try to reach out to the public and help them. So you can contact the Orange County Bar Association's Lawyer Referral Service, and Lawyer Referral and Information Service. You'll get that information through the folks who are putting on the presentation tonight. They'll send that to you. You can get a referral to an attorney for a free 30-minute consultation. You might be charged for speaking with them for a little bit longer, but the initial consultation should be free. There may be some specific types of cases where there is not a free consultation, but they will let you know that when you call or try to get that referral for an attorney. But other than that, we thank you very much, and we appreciate the time to hear from you all, and we wish you the best.
Yes, I'll be sending you all an email with information and resources that were mentioned in today's event for you guys. And hopefully you guys got your questions answered. And if you have any more questions, you guys will be able to use those resources to get more information. Thank you all so much for your time, and I hope you have an amazing evening.
Thank you.
Good night.
Good night.